Shirley, good morning, everyone. I'm going to talk through the changes to the IR35 legislation that have recently been implemented. IR35 legislation was initially brought out in April 2000 and was aimed at tackling what the revenue perceived to be a reduction of tax intake by individuals working through public service companies who otherwise would be deemed as employees. And by operating through the public service companies, or personal service companies, they would be paying less tax and national insurance. The IR35 legislation was reformed in April 2017 and affected the public sector, and famously the BBC ended up with quite a lot of their journalists and reporters being affected by this, as the majority of them were operating through personal service companies. In April 2020, it was expected that there was going to be a further reform to the IR35 legislation to affect the private sector and any public bodies such as GP practices. But because of the COVID pandemic, this was delayed until April 2021. So now GP practices who engage the services of a locum GP through an intermediary, so that will either be a limited company or an agency, or have long-term locums working for them under a prolonged period of time, or GPs providing out-of-hours work, will now be affected. Up until April 2017, it was the responsibility of the personal service company to assess whether they were subject to IR35 legislation. And unsurprisingly, under a self-review, quite a lot of people deemed that they were not affected. Now, from April 2021, it is up to the individual practices to assess the locum GPs to see if IR35 rules actually apply. So if you've got any locum GPs that are working for you through an agency or a limited company, then you will need to look at potentially assessing them. So the key indicators and questions for IR35 are the obligation to work. So who has control over the worker and who sets the hours and rates of pay? If the individual that is providing the services sets their own hours and rates of pay, then it is less likely that they're going to be within IR35 legislation. There is the grey area where a locum works for a GP practice, in that the GP practice is going to set the hours that they are going to predominantly be working. If the individual supplies their own equipment, then again, they're less likely to be within the IR35 legislation. But if the majority of the equipment is being provided by the GP practice, you would also need to consider that as potentially being an employment position rather than a self-employed position. If the individual is able to substitute themselves for another suitably qualified GP and this substitute cannot be rejected, again, that would indicate that IR35 legislation does not apply. In practice, does this really happen if you contract with a locum to undertake work? If they can't undertake the work, I'm guessing in the majority of cases you would go out and source another locum to undertake any sessions on your own accord. Another indicator that IR35 might apply is if they work regular sessions. Would this be treated as employee position in any other circumstance? You need to be looking at this when looking at self-employed locums as well. So if you've got a self-employed locum that's working for a period of time for maternity cover, and you know at the end of the maternity cover the locum position is going to come to an end, IR35 will most likely not apply and they can continue to invoice you on a self-employed basis. Alternatively, if you've got a long-term self-employed locum that works regular sessions and there is no deemed end period for this employment position, they would most likely fall within the employee regulation and should ideally be processed through the payroll as an employee post. So there is a checking website, the link is on the slide, that you can use to determine the status of a locum GP. If the answers provided within the link are answered truthfully and fully, HMRC will stand by the determination that's provided. If it's deemed that IR35 applies, the practice is responsible for deducting the tax and national insurance of the employee as if they were an employee and declaring this through the payroll, and they must provide a payslip and a P60 to the locum GP. As it's not an employed position, no pension will be due on this income because it will be paid to the limited company. The GP practice will also be liable for paying the employer's national insurance contributions on this income on a month-by-month basis as they're processing the payroll. The locum GP working through an agency or through their own personal service company will be treated as a worker, and therefore not all of the employment rights would be applicable to them. So as they're deemed to be a worker, there will be no minimum notice period if their employment will be ending. They have no protection against unfair dismissal. They will not be able to request flexible working hours. They're not allowed time off for emergencies, and there is no statutory redundancy pay. So prior to the 6th of April 2021, any agency that provided locum services or services through an agency, it was the agency who were subject to determining whether the engagement was subject to IR35 and applying the IR35 legislation. From the 6th of April 2021, that has all changed. Now it is the practice who are receiving the services of the locum GP that will need to undertake the determination. Once the determination has been made, the practice will need to tell the agency and the locum GP of their determination and apply the IR35 legislation applicably. So we also would be looking at where locum GPs are providing services in their own right as self-employed locum. If that's over a prolonged period of time, then they will need to potentially consider being treated as an employee, and these things need to be looked at with the indicators of what would be an employed position rather than a self-employed position. If HMRC were to ever investigate and find that a long-term locum GP should have been treated as an employee, any payments made to the locum GP will be treated as being net of tax and national insurance. This would mean that the practice would therefore be charged the tax, national insurance and pension contributions on this net payment, and it could result in a significant additional tax liability for the practice on this income. So as IR35 is a complex area, and the determination of employed versus self-employed needs to be looked at on a case-by-case basis, it needs to be now the practice that are undertaking the determination and printing off the determination from the website once it's been undertaken and keeping evidence that they have considered the IR35 legislation in full. So that brings me to the end of the IR35, and I'll pass back to Shirley.